So again, welcome everyone to our relatively short lecture on expert witnesses. Now, the reason I'm keeping this lecture relatively short is because expert witnesses can be very, very tricky to deal with. So we're only going to look at it kind of an introductory approach to expert witnesses, whether we allow them, how we allow them, etc. So that being said, let's jump in. So we've discussed before that most cases never go to trial, right? Maybe 5 to 1% of cases go to trial. Of those cases, most civil and criminal trials involve the use of expert witnesses. Expert witnesses are regularly called to testify about matters that are beyond the juror's personal experience. Right? So if we think of civil cases, this can include treating and non-treating physicians, so doctors, design engineers, civil engineers, people who design bridges, things like that, and even accountants. There is no real end scope of it. It can be literally anybody who's going to help the jury. In criminal cases, we're going to look more towards pathologists, right? Chemists, people from the drug lab, and gang experts. Now, again, this list is not exclusive, and we're going to see that generally speaking, if somebody has knowledge that is beyond the perception or the experience of the jury, they'll be qualified as expert witnesses, and their whole goal is not, they don't have a dog in the fight. Their whole goal is to just tell the truth to their expert opinion. And that's the goal. In reality, does it happen? Usually, but sometimes it does get a little into the gray zone. Now, that being said, a good trial lawyer must know the applicable law, right, in both federal courts and in state courts. More so, and way more importantly, the lawyer must understand the jury's perspective, right? So the whole point of expert witnesses is to help the jury. Now, when done well, experts can explain reality by helping jurors understand complex and technical evidence. Done poorly, experts only bore, overwhelm, and confuse jurors, right? So it's interesting. We might find what we think is the most qualified person on earth. Or we might find somebody who has a degree from MIT, a degree from Harvard, a degree from Yale, and we're going to say, yeah, we want them to be our expert because they know their field, they're at the top of their field, etc. Well, that works to a certain extent, but if that juror, or excuse me, if that witness is not jury friendly, cannot dumb down what's happening, the jury doesn't care about their qualifications, right? Because they're going to stop listening. As soon as we get into like technical language that the expert doesn't really explain or doesn't put in everyday people terms, it's going to bore them, it's going to overwhelm them, they're just going to tune it out. So again, having well-qualified experts is essential, but you have to make sure that they are able to testify and do it in a way that is effective for juries. That being said, there are people who make living testifying as expert witnesses. So they fly all over the country and they testify as an expert witness based upon the examination they did or whatever it is. And they get paid very, very, very well, which is always a point of attack, right? You call an expert witness, you're gonna say, well, you're being paid $10,000 to be here, aren't you? Right, and it kind of like gives that hint that you might be altering your testimony. And again, expert witnesses should not be altering their testimony, right? They're there just to present the facts, to explain them to the jury in a way that the jury can understand and explain what they found. So, that being said, When we qualify somebody as an expert witness, expert witnesses must pass 3 sets of evidentiary and procedural barriers. First, they must comply with the rules that govern the direct and cross-examination of any witness, right? So yes, they are a special witness, but they have to abide by the rules for every witness, right? So one of those things is relevancy. If you call a gang expert to testify in a trial that involves a bar fight, we're probably going to say, is that relevant? Right? I mean, in other circumstances, it may be, but it doesn't seem relevant off the course of top of our heads. So being said, that's our first barrier. Assuming that we can get past that barrier, right, that we treat them like any other witness, then they must comply with the, quote, special rules that govern the testimony of expert witnesses. So these rules are found in the Federal Rules of Evidence, number 701 to 706. In addition, they must comply with case law since 1993 that has substantially altered the admissibility requirement for expert testimony. So if we look at Federal Rule of Evidence 702, an expert may testify his testimony will, quote, help the trier of fact to understand the evidence or to determine a fact an issue. All right, so this is kind of what we're saying, that expert witnesses are there to help the jury understand really complex terms. All right, so you might say, well, I did a C7 scan analysis with a blue backdrop, and you might just go off on this tangent, and the jury's not going to understand what the hell you're talking about. Right, and the whole point of the expert witness is to explain to them in real people terms what they did, what they found, why they found it, and why they're reliable. Now, the rule is silent on how well qualified the expert must be. Right, so an expert witness has to be qualified as an expert by their knowledge, by their skill, by their experience, training, or education. And so this means that we don't just look at people who have graduate degrees or PhDs. This means that if we want to call a mechanic as an expert witness, we know that they have knowledge, they have skill, they have experience, and they have training, right? And we're going to ask them about it to qualify them as an expert witness, even if they don't necessarily have education, right? They may not have graduated high school, but if they are a great expert mechanic, then there you are. Now, as I said, the rule is silent on how qualified the expert must be. In federal courts, the standard has been very generous. Most judges will accept any expert who has knowledge superior to that of the jury, I should say. So historically, we've been very lenient and said, okay, well, we'll qualify them as an expert because they have some kind of specialized skill or specialized knowledge or whatever. That being said, in recent years, many judges have become more demanding and require that experts have actual expertise in the specific subject in issue which the testimony is directed, right? So maybe we're not talking just a mechanic, but we're talking a mechanic that works on specifically exhaust systems, and that's all they do, right? So if we call it a general mechanic, yeah, they might have worked on some exhaust systems, but if we call somebody who works exclusively on exhaust systems, then we're going to probably get them in as an expert, right? And again, knowledge, skill, experience, training, or education come into play. So how do we determine the relevancy and the reliability of experts, right? So for decades, the admissibility of expert testimony in both federal and state courts was governed by a case called Frye v. United States. It's in 293 Fed 1013. It's a 1923 case, right? And we had to follow Frye. We'll talk about what Frye basically did. Frye basically had standards that you had to meet in order to be qualified as an expert witness, in order to testify. That being said, in 1993, when the Supreme Court decided Daubert versus Merrill Dowell Pharmaceuticals, 509 US 579, this completely changed, right? So instead of having to meet specific criteria under Frye, and this is what we're getting at, we had to meet specific criteria. What happens is in Daubert, and again, this only applies to federal cases at this point, the judge serves as, quote, the gatekeeper, right? And as the gatekeeper, the judge must determine if the proposed testimony of any expert is relevant and sufficiently reliable for the jury to hear and applies the facts to both. So what basically happens is Frye said you have to meet these certain standards. Daubert said, well, those standards aren't necessarily the best things that you have to meet. We'll take them into account, and we'll explain those later. We'll take them into account, but ultimately, in deciding somebody is an expert and deciding whether they have sufficient expertise, we'll lay down to the judge, right? And generally speaking, we will not second guess the judge on appeal. That being said, there are two real types of experts that get involved under Daubert, excuse me, the Daubert Standard. And the first is scientific experts, right? So these are the ones who base their testimony on scientific tests and methods. So this is the coroner, right, who did an analysis of the liver, or whatever you have, right? They're science. The other type are training and experience experts. And so these are experts who base their testimony on personal observations and experiences, right? So you may say, well, the police did X, Y, and Z, and you might call a retired law enforcement officer, right, who had executed warrants before. And the law enforcement officer said, yeah, in my experience, you don't do X, Y, and Z, you do A, B, and C, right? So again, in this case, he's not using science, but using personal observations and personal experiences. Now, if we think about the expert witness as the gatekeeper, under Federal Rule of Evidence 702, the judge must determine if, one, the testimony is based upon sufficient facts or data, two, the testimony is the product of reliable principles and methods, and three, the expert has reliably applied the principles and methods to the factors of the case. So this is really what we talked about when we're talking about Frye. This is generally what they required in Frye. The idea in Frye was like it had to be generally accepted among the scientific community. Well, the problem with that is it does not make a whole lot of room for new technology, right? So one thing we're talking about is DNA. DNA and forensic purposes didn't come about until the late 1990s, right? And so if you tried to use DNA before it was generally accepted, under 702 and under Frye, it wouldn't have come into evidence, right? And then Daubert comes, and Daubert changes things, right? So we still have to abide by Rule 702. We still have to say there's sufficient facts or data, product of reliable principles, expert has reliably applied the principles and the methods to the facts of the case. Now, when making this decision under FRE 702, the judge makes the determination by applying what's called the Daubert factors, right? So from Daubert versus Merrill Pharmaceuticals. And so the judge asks a series of questions, right? Or has to answer a series of questions to himself or the expert witness. One, whether the theory or technique has been tested. Two, whether the theory or technique has been published and peer-reviewed. Three, the known potential error rate. And four, whether the theory or technique has been generally accepted by the scientific community. right? And so these factors obviously apply to scientific experts. But what we see is we kind of see a mesh, right, of Frye and Daubert, which says, look, it's up to the judge, right? And so the judge has to say, is there a test? Has it been tested? Do we know how many times it gives us a false positive or a false negative, et cetera, et cetera, et cetera. So this is how judges make their determinations under 702. They have to apply the Daubert factors. Now, Daubert, it does make room for new types of evidence, I would say. So if we think about DNA, again, not till late 1990s, Daubert is great because we can say, has the theory been tested? And as long as it has, then yeah. Has the theory been published or peer reviewed? Well, maybe, maybe not. Do we know potential error rate? Sure. Has the theory been generally accepted by the scientific community? Maybe that answer is no. Now, the answer doesn't have to be yes to every single one of these questions, and none of these questions are determinative. Instead, keep in mind, the judge serves as the gatekeeper. So the judge gets to say, yeah, no, I don't like that. That doesn't sound reliable. That sounds really out there. We're not going to do this. And again, the judge is thinking about the jury and not wanting to confuse the jury. So that's where the gatekeeper kind of comes into play is, yeah, say the judge has to abide by 702 using the Daubert factors, but at the end of the day, the judge is the ultimate determination as to whether an expert is allowed to testify or whether an expert is not allowed to testify. So, most states have adopted Daubert, right? So the feds have adopted Daubert and most states have adopted Daubert. A minority of states continue to use the Frye Standard, right? So remember, under Frye, an expert may testify if the tests or principles underlying the expert's testimony, quote, have gained general acceptance in the particular field in which it belongs, end quote. Right, so this is one of the factors of Daubert, but for Frye, this is the factor, right? And as you can see, it is a hindrance to new forms of evidence and new procedures. Right? It has gained general acceptance in a particular field. Well, DNA took decades to gain general acceptance, right? So if you come out with this DNA and you say, oh, look, this proves this person is innocent, and we're following Frye, the Frye is going to say, well, it hasn't been accepted by all the experts in the field, so I'm not going to allow it, right? So that's why Daubert, this is one of the factors that gets considered in Daubert, but it's not the standalone factor, right? So Daubert allows for more creative, more innovative ways of introducing evidence or procedures for processing evidence. That being said, the states that follow Frye, right, so that have not adopted Daubert include California, Florida, Illinois, New Jersey, New York, Pennsylvania, and Washington. And so in those states, you do not use the Daubert standard or the Daubert test, you use the Frye standard, the Frye test. Now, this gets interesting because when we look at the populations of these states, like for instance, California, they're under court order to release a lot of their prisoners because their prisons are overflowing. Well, let's say we come up with some new idea, some new test, and we can tell if they're guilty or innocent. Well, in California, that has to gain general acceptance in the community. So that's going to be published peer-reviewed articles, testing, retesting, retesting, etc. Meanwhile, innocent people are sitting in prison. Right? Daubert says, well, that's one of the factors, but if it's reliable, we know the error rate, et cetera, then we're going to allow it in. Right? So California might not be in such a bad place, had it adopted Daubert instead of using Frye. And of course, we have Florida, Illinois, New Jersey, New York, Pennsylvania, and Washington. So that being said, what I'm going to end with today is just some short testimony of an expert witness. So you get to see what that looks like in practice.
This personality profile tend to experience a lot of aggressiveness, hostility, defensiveness. But interestingly, these individuals do a relatively good job on a day-to-day basis of not displaying it to people. So this isn't someone who's walking around consistently hostile, throwing things where it's visible to other people, but they're still experiencing those emotions inside. In times when they feel like they've been wronged in some sort of way, or when someone has done something to hurt them that they perceive as hurting them in any kind of way, the way that it's described in the literature is they have these violent outbursts that are described as seething, as very angry. And what they tend to do, what this profile suggests, is that these individuals tend to externalize blame. So for example, I acted out this way because that person deserved it. So they externalize it. They say, it's not my fault. I didn't act this way because I have these strong emotions inside. I act this way because someone did something to me. That's how they're able to conceptualize it and justify it in their mind. When I first started reviewing the records, there was indication in those records that there was a sense of immaturity that was present. For example, in Ms. Arias's booking profile, the way that she took the picture, she kind of smiled as though it was a high school photo rather than a booking picture that you would typically see. This to me was strange. I found it to be strange and immature. There was also the things that happened surrounding that suggested that there was, again, some immaturity there, such as her parents had indicated that she was described as being happy as hell when they came to visit her in jail. There was behaviors like this that were aberrant, that were strange, and it made me wonder whether there was some sort of intellectual deficit there that could be contributing to this, which is why I gave the intelligence test. I diagnosed her on Axis 2 as borderline personality disorder.
What does that mean?
Generally, borderline personality disorder, you can think of it similar to what we see in teenagers often. This sense of immaturity and what's called emotional lability, and I'll talk about that in a little bit. But generally, it's about instability. There's unstable interpersonal relationships, unstable emotions, and an unstable sense of identity, meaning who am I as a person? There's this constant fluctuation. There's a lot of manipulation that's involved with people who have borderline personality disorder, and a large sense of immaturity. You can, again, think about a teenager. What we see in people with borderline personality disorder is that they engage in behaviors to try to keep people close to them. But ironically, these kinds of behaviors often push people away. So in the case of Ms. Arias, this was demonstrated throughout her relationship, well, throughout life, and also with Mr. Alexander. For example, after they broke up, when they broke off their relationship, she then moved to Mesa to be closer to him. This fear of abandonment, this tendency to overstep boundaries, to be intrusive. Ms. Arias herself notified me that she had checked his Facebook without his permission, read text messages without his permission, engaging in these kinds of behaviors of, don't leave me, let me see what you're doing, I want you to be near me. There was indication from friends that highlighted her tendency to engage in these intrusive behaviors by spying on him, by being intrusive with his space in general. She had a very strong tendency to go from boyfriend to boyfriend, one after another, which is also another example of fear of abandonment that I just highlighted. What I found is in these relationships, there was a very strong tendency to idealize the men that she was with. For example, she had indicated to me that Mr. Alexander was not faithful to her during the relationship, but nonetheless, she still had this devout love for him. And you can see within.
So we'll stop the video right there. You can watch the rest of it on your own using the link that is in the PowerPoint. But I just wanted to point out, this is a great expert witness, right? So expert witnesses, we usually allow them to go on. And if like the lawyer needs clarity, they'll say, can you clarify that? Or can you speak to that more? But she's great, right? She's calm, she's looking at the jury. She is talking about personality disorder. She is well-spoken. Obviously well-dressed, obviously somebody who's done this before, right? Which is great for getting the jury's trust, but also she understands how to explain things to a jury, right? So when she talked about personality disorder, borderline personality disorder, she said, think of a teenager, right? And that will instantly resonate with everyone on the jury because all they have to do is go, oh, yeah, okay. I remember being a teenager, or if they have teenagers, or if they had kids who were teenagers, they're going to recognize this and go, yeah, I see what you're saying, right? As opposed to just saying she had borderline personality disorder and moving on, because that doesn't tell us anything, right? Unless you're a psychiatrist, you probably don't know what borderline personality disorder is. And again, unless you have the DSM-V in front of you. So it's a great example of expert testimony. She's obviously has been qualified. Oftentimes, it's best for the parties to stipulate if they're calling expert witnesses that the other party is an expert, because generally speaking, you don't have to lay the foundation that you normally do for an expert witness before you consider them an expert. Right, so you'll lay a small foundation, where'd you go to school, what were your grades like, blah, 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 for the judge. But what the jury really cares about is what is being said, right? And in this case, they qualified her as an expert witness, so they didn't have to go all the way into voir dire, but they could if they wanted to voir dire the witness. And instead, they let the expert witness talk. And she, like I said, she was absolutely great. She gave reasons for her decisions, reasons for her diagnosis, everything under the sun was taken care of. So that being said, what we'll do is we'll end the lecture there. Next class, we're going to look at objections. If you have any questions, always feel free to reach out to me. Thank you so much for watching. I'll see you soon.